Good morning, Your Honors. May it please the court. David Noel on behalf of the appellant Heritage Property and Casualty Insurance Company. I'd like to reserve 5 minutes for rebuttal, please.
Yes, sir.
Your Honors, we're here today on de novo review of the trial court's order compelling an appraisal in this particular case. And the trial court reversibly erred by compelling that appraisal, despite the fact that there was no right insurance claim to send to appraisal. And it is de novo review because it's a question of law. The trial court erred by failing to consider 2 legal doctrines and apply them to this particular case. The first legal doctrine is that a wholly denied insurance claim is not ripe for appraisal. And
is tell me the chronologies. Was the initial claim adjusted at the time what you were contending as a supplemental claim was filed?
Yes, Your Honor. So the initial claim was
correct me, I'll confess I need to be refreshed. I thought it was going to, the last minute, the 11th hour, that the roof claim was that they declared that they were cover the roof claim. So when was it adjusted for the purpose of the determination of whether it's something?
So the timeline in this case is very important, and the initial coverage determination went back to December 5th of 2017. And that particular determination was that the initial roof claim was below deductible. The estimate was $9,500.
So at that point, any other claim is supplemental, even so, because that constitutes an adjustment?
Not any other claim is supplemental. A new claim that comes in for additional recovery.
Oh, yeah, I'm saying is an adjustment the juncture at which something chronologically is supplemental?
Not so much, Your Honor, because
that's the word used, isn't it?
The focus in the briefs was the policy definition of a supplemental claim, and that's what guides us since it is a contract case. And the significant language in that definition of supplemental claim, which is in the Florida Changes endorsement of the Heritage policy, it says an additional claim for recovery. So in this particular case, in the chronology, once the public adjuster comes onto the case in March of 2019, we have 2 requests by the public adjuster. We have a request for greater valuation on the roof claim, the initial roof claim, saying, no, it's not actually below deductible. The repairs are not working. There's still leaks happening here. So we need full roof replacements on the initial roof claim, but also submitting the additional claim for recovery of a full replacement of all the windows and doors.
Your position on the claim that came in after the public adjuster claim was that, and correct me if I'm wrong, the supplemental portion of the claim was doors and windows. Did it include the additional charges for the roof replace versus repair, or was the supplemental under your policy definition limited to the doors and windows?
The supplemental under the policy definition was limited to the doors and windows because that was the only additional claim. The roof claim was going back to the initial claim. It wasn't additional. It was the same thing. It was simply a continuation of that initial roof claim saying repairs are insufficient. That $9,500 estimate that's below deductible is not getting the job done. It needs to be full roof replacements. That's not an additional claim for recovery. That's simply a continuation of the initial roof claim. Whereas the windows and doors, consistent with this court's Ironwood case, is a supplemental claim because it's something completely new. It was never submitted.
Is it your position that the policy language at issue in the Ironwood case, which is similar to but not exactly identical to your policy language, is it your position that they should be read as indistinct?
Yes, Your Honor. The differences are only stylistic, and for all substantive purposes, the language is essentially identical.
At the end of the day, your position is Ironwood controls. You have essentially the same chronology, essentially the same policy language, and the holding of Ironwood was you don't have the supplemental claim. You don't have coverage on the supplemental. The coverage determination on the supplemental claim hasn't been made, so it's not right for appraisal. right? That's
yes, Your Honor.
And of course, we know that Ironwood has been tagged on to the cases that are pending in the Florida Supreme Court having to do with the question of appraisal in whole for the claims. And so what should we do about that?
That's correct, Your Honor. And I know that the Florida Supreme Court proceedings are going to focus on whether the dual track approach should be used or whether the Fort DCA's approach of always determine coverage first should be adopted. But in this particular case, we're not arguing against the dual track approach. We're not suggesting that this court's Leeward Bay case or this court's Villaggio decision were improperly decided. Our arguments in this particular case are consistent with both of those two cases from the court. And in particular, the language from those cases, starting with Leeward Bay, which came first, it starts off in the analysis of this court by talking about when a demand for appraisal is right. And it says a demand is right where post-loss conditions are met, which we have here, where the insurer has a reasonable opportunity to investigate and adjust the claim, which we had once we reached those April 2021 letters. And then third, and most importantly, demand is right when there is a disagreement regarding the value of the property or the amount of loss.
Well, my question is a little more specific to what's going on in the Florida Supreme Court. And they can certainly rephrase the question, but they have accepted jurisdiction. And the question that they're reviewing, as I understand it, or at least the question that's certified, is whether appraisal is always inappropriate before a coverage determination is made, or whether the trial court can discretionarily order a dual track appraisal of litigation while the legal, so that you're simultaneously litigating the coverage question. I'm not sure it's quite as limited as you're suggesting. And I think that leaves us with Ironwood is tagged in the pipeline to the Leeward Bay case, and there's a good chance we're going to get whatever the answer is that probably may cover all of these cases or not. But we either follow our panel decision in Ironwood, or we have to address what's going on in the Florida Supreme Court. Is that where you ultimately end up here, or if I missed something about what's going on in the Florida Supreme Court?
That's definitely accurate as to the Florida Supreme Court proceedings, Your Honor, but under either legal framework, the trial court's order that we're on appeal here with today would require reversals. So what happens in the Florida Supreme Court would have no effect on this particular type of case. And that's
so essentially what you say is, as of today, regardless of the Florida Supreme Court, Ironwood requires reversal.
Not just Ironwood, Your Honor. Ironwood is one of the legal doctrines that the trial court missed. The second one, because Ironwood is essentially saying that there's a supplemental insurance claim here, and that requires a separate coverage determination, and then we can determine if we go to appraisal. But the second thing that the trial court omitted is the Johnson case from the Florida Supreme Court, which holds that where coverage is wholly denied by the insurance company, you don't have an amount of loss dispute anymore. And that's the critical factor here.
Although in our Leeward Bay case, I think we opined that Johnson may not be quite as robust for the proposition that you're advocating right now. And that's part of what's put to the court in the certified question, isn't it?
Your Honor, Leeward Bay is a little bit different. Certainly factually, it's very different from our case here. In Leeward Bay, coverage was initially accepted by the insurance company, and then they reversed course and said, no, the policy is void because it came back to us with too large of an estimate.
Which is altogether different.
Which is completely different than the facts of this case. But even more so, before the court reached that particular holding in Leeward Bay, there was the discussion of whether the claim is right for appraisal in the first place, which is the first hurdle that had to be overcome before the court could look at the dual track and proceed to the final holding. And that third prong of that determination of whether it's ripe or not is whether there was a disagreement regarding the value of the property or the amount of loss. And this court found that that was present in Leeward Bay by stating that American Capital's position at the hearing confirmed that it disputed the amount of loss. because the question was the estimate too high? In this particular case, there's been no dispute about the amount of loss. For the supplemental claim, all the windows and doors.
Oh.
So the initial roof claim, Heritage agreed.
The supplemental was you're saying was denied. You're saying that there's. Let me ask you this. Maybe I'm the slowest kid in the class and I need help. There's no. You're saying the dual track issue is inapposite, or it's just not relevant here because there's no other track. There's no other track. There's only one track.
Exactly. So whether we use dual track or something else, there's nothing here in this case.
The reason there's no track is because your client outright denied the windows and doors.
Exactly. We outright deny the windows and doors, so there's not an amount of loss dispute.
There's a dispute amount of loss because you're saying it's 0 and 0 and 0, 0, 0 and nothing else. Because we don't cover that. And my question, again, and maybe injecting something that shouldn't be injected where it doesn't belong, but is what I wanted to discuss was the term adjusted in the definition of supplemental claim. Because it seems that chronology is important for the purpose of bringing this outside the ambit of the dual track debate and its Supreme Court, which is that we eliminated when you eliminated the second track, which we're making the track, had the first claim been adjusted, because my reading of the definition of supplemental claim is or additional claim for recovery from us for losses, which then what we had previously adjusted was the initial claim. But here, wasn't there a last minute decision to adjust it differently than the initial adjustment? Said, okay, fine, we'll pay for the roof. So was the adjustment, when was the supplemental claim filed in that chronology?
The supplemental claim was filed on March 6th of 2019. The adjustment of the initial roof claim was completed on December 5th of 2017, because that's when Heritage issued their coverage determination letter finding that that roof claim was below deductible. So that's the adjustment. Then 15 months go by and a public adjuster sends a letter to Heritage saying, on the initial claim, we think it should be a higher value on the roof. It should be full roof replacements. So then there is a continuation of that initial claim.
What happened with the supplemental demand on the roof claim?
So what happened with the continuation of the initial roof claim was that the court ordered a continued examination under oath of the insured's representative. And after taking that EUO, Heritage agreed to pay the entire estimate for the full roof replacements.
So the roof claim is out at this point. There's no controversy over the roof claim. There's no remaining issue regarding coverage and nothing to appraise on the roof because the plaintiff has been fully satisfied.
Correct. Like Ironwood, the roof claim has been completed at this point, nothing to send to appraisal.
And that payment was issued sometime frame after the March 19th demand following the public adjuster, but whatever it is, it's over.
Correct, Your Honor. It was issued, I believe, July 2021, so it's concluded. It was after the trial court issued the order to go to appraisal, but that has been concluded. And with respect to the supplemental windows and doors claim, Heritage is not arguing that the $3 million estimate to replace all those windows and doors should be $1 million, or it's too high, anything like that. It's fraudulently inflated. If you read the denial letter that Heritage issued, it's talking about there's a lack of damage here. There's a lack of scientific testing procedures.
So here's the thing, though. Your client, having gotten the demand for the full roof replacement in March of 2019, waits until after the appraisal is ordered to pay by the trial court to issue full payment for the roof claim, and then says, aha, the rest of this can't be appraised, we're out. The timing of that is, the optics aren't great, you agree.
Well, Judge, the record does reflect that Heritage was continuing its investigation and had to take multiple examinations under oath due to the insured's conduct.
Does that mean it wasn't adjusted yet? And can they slip in the windows and doors and make it a part of the initial claim because the insurer hadn't adjusted the roof claim yet?
No, Your Honor. Pursuant to that definition in the policy, it just requires adjustment of a claim regarding the same hurricane. In terms of being a supplemental claim, if it's requesting additional recovery essentially additional damages from that same hurricane, it's going to be a supplemental claim.
Maybe.
And Ironwood really speaks to that.
Aren't there two prongs here to the definition, additional and previously adjusted? So if it was just, hey, you know what, you submitted a claim and that's a roof claim, and now you want one of those doors claim, that's additional. So that's something else. But doesn't the definition and the policy say which we have previously adjusted? Well, I guess, but perhaps I'm wrong, and I'll argue against my hypothetical devil's advocacy and say, is it the losses from the same hurricane which have been previously adjusted? So
exactly, Your Honor. In terms of previous adjustment, they're talking about the same hurricane. And here it is the same hurricane, it's Hurricane Irma. The court did kind of look at this analysis in the Ironwood case and concluded, consistent with our arguments here today, that it was a supplemental claim with all the windows and doors being requested to be replaced. Ironwood had the same expert company, Moisture Intrusion Solutions, on the insured side.
Just to let you know, you're
yes.
Coming into your rebuttal time now.
Okay, thank you. Thank you, Your Honor.
Good morning, and may it please the court, Terry Goggin on behalf of the appellee, Rand 1. As Your Honors are likely aware, this is one in a line of recent cases pertaining to the appraisal policy or the appraisal provision within an insurance policy. And I think first, to kind of clear up some of where we sit as far as the lay of the land is concerned with the recent rulings, this court in its Leeward and Bellagio opinions, namely, has adopted, I guess, the appraisal of the loss. And I say that very specifically, in line with Lycia, Johnson, the Gonzalez case that Johnson basically quotes, and so on and so forth. More recently, borrowing from the Goldberg decision, which articulated that a supplemental claim, well, I guess it articulated the definition for a supplemental claim where I guess this particular provision within a policy could be read a couple of different ways. It says, basically as argued by the appellant here, that any previously adjusted claim where that adjustment pertains to the same hurricane ultimately will give rise to a supplemental claim, and so on and so forth. This court's opinion in Ironwood ultimately speaks to this ripeness issue, where a supplemental claim has been made the inquiry or the subject of inquiry. The first inquiry is whether appraisal is appropriate at all. And that pertains to the scope loss, as opposed to the ripeness, which has been made to pertain to the scope claim. I use these terms very deliberately because if we actually read the appraisal provision within the policy, it says, if you and we disagree as to the value of the property or the amount of loss, an appraisal of the law, either may request an appraisal of the loss in writing. It goes on to use the term loss again and again and again. Now, the purpose of compliance with post-loss obligations is articulated in the Romay case, which suggests that—
But going back to the policy language though speaks in terms of when you actually refer that to the appraisal process, you're referring a claim to the appraisers, correct?
No, it says the amount of loss is referred to the appraisal panel. An appraisal of the loss.
Are you looking at the duties in the event of loss or damages, which define supplemental claim, or are you looking at the appraisal?
Your Honor, we're looking at the appraisal provision. I believe in this case, it's the appendix at page 70. It is a subtitled Mediation and Appraisal. The articulation of a supplemental claim, that definition is actually contained in a separate, I believe,
duties in the event of loss or damage.
Yes, that is in the Florida policy changes part, I believe, and it pertains to the time in which a supplemental claim must be brought. And this was done in response to these two cases, Hernandez and Fernandez, wherein a claim was, well, the loss accrued in 2005. The claims were ultimately brought in 2010. I believe those cases were treated briefly in the briefs. And ultimately that was limited by the policy. And that's where this definition of supplemental claim occurs. It also occurs in the same context in the statute. Here, where we look at the mediation or appraisal provision, the mediation or appraisal provision articulates that an appraisal may request an appraisal of the loss in writing. In event, each party will select a competent or partial appraiser. The two parties will select an umpire, blah, blah, blah. And the appraisers will state separately the value of the property and amount of loss. Ergo, the appropriate scope of inquiry for determining whether or not a case should proceed to appraisal, not the ripeness, that's just a matter of timing, but whether the case itself should be subjected to this dual track process. I know this is a distinction that I think is one that's been lost, and I think deliberately so, because initially in the Leeward-Bellagio claims, these all mention loss, and it was argued as a loss. This loss should not go to appraisal because we have a defense of fraud, we have a defense of misrepresentation, and so on and so forth.
Wasn't the nut, though, of Leeward that because of the way the coverage dispute developed, the court determined that in that particular case, the amount of loss was necessarily involved because coverage dispute is intertwined with the amount of loss. And the reason for that was the insurer viewed the claim that the insured submitted as being so inflated as to be fraudulent.
So ultimately, there was never this separation between an initial claim and a supplemental claim. The terms, and this has been the case throughout most of the case law, the terms claim and loss have been kind of used interchangeably here and there, one substituted for another. But now they've been put specifically at issue in the wake of Leeward and Ironwood. So no longer was it acceptable to just say, there's an inflated amount, we have a defense. Johnson and Lycia clearly contemplate that these defenses are ultimately reserved. These are coverage defenses. And I think the ultimate holding of Leeward and Bellagio and kind of clarifying this, and certainly conflicting with the Fourth DCA's opinions in Corridor, Michigan Condo, and whatnot, is essentially saying that these defenses, and this is derived from Johnson where it explicitly mentions, these defenses are reserved for later determination by the court. The ultimate question of coverage, and therefore ultimate liability, is an issue for the court to determine. It's something that will go to trial. This is a limited process intended only to determine the amount of loss. It is not a binding determination of liability, and that is where it separates itself from arbitration, where everything is swept.
Well, here, we don't have so many complications, and I think that's how Ironwood wound up being resolved the way that it was, which is we have a claim that the insurer never, for these windows and doors, the insurer never accepted coverage. They're different, windows and doors are different than the roof. And the claim didn't come in until after at least the initial adjustment of the roof claim. So, and the reasoning, and this is what the court has adopted wholesale, and we recognized in Ironwood, is it doesn't make a whole lot of sense to go through the appraisal process and the expense of all that if at the end we come back to the court or simultaneously determine in the court that there's no coverage, because then the loss doesn't mean anything anyway. So while it's interesting to go into the whole doctrinal underpinnings of Leeward Bay and et cetera, isn't that ultimately the question, is judicial economy?
Yes, I think so, precisely. And in Ironwood, the ultimate holding is whether a coverage determination has been made is indicative, in an attempt to make it more objective, of whether or not sufficient, as Leeward stated, investigation, reasonable opportunity to investigate has occurred in compliance with post-loss obligations. Here in this particular fact pattern, we have a hearing on April 13th, 2021, where two letters were issued, introduced, and discussed. Both are discussed in the briefs. One says that first claim, that initial claim that we disputed, we now don't. We're paying the entire thing. And the second one says, and that second claim, now this, again, we contend is now a fabrication. We had one loss that was going to appraisal. Now we have these two claims. They're both being stated very differently as of this hearing. The second claim, there's no coverage for that. But what does this determination of no coverage mean? They've sent a letter. The judge hasn't decided this. We didn't agree. This is a dispute as to the amount of loss. They simply say there is nothing else.
But you know that the formal denial of a claim by an insurance company carries repercussions.
Certainly it does. Unfortunately, those repercussions are things that will be addressed in extra contractual claims after, and I think
they get to cross the Rubicon and then avoid appraisal and then suffer the repercussions.
It's a good metaphor.
So, I mean, I think, ultimately this is a matter of economy. We can go to trial. We can bring in experts to trial that will attest to the scope of loss, which is what appraisal intends to do. We can bring experts into trial to attest to the amount of loss and have them go through a 3-4 week process in these larger claims, such as Leeward Bellagio, the one at issue here. Or this can be sent to the appraisal panel, where you have an appraiser and an umpire. And these industries—
We've got a legal determination, a trial judge to make that summary judgment. Is the claim covered or isn't it?
I hate to say so.
Legal determination, isn't it?
So ultimately, that is what I think trial court has determined. Well, that is a complex issue because there is coverage, as in, does this policy pertain to the property? Does this policy pertain to the covered peril or the proposed covered peril? And those two things, the answer here is yes, the property is undeniably covered, quote unquote, by the policy. And I think this is another word that bears closer, I guess.
Sure, but I think what the insured here determines is that there was claims, the loss that was claimed wasn't covered because it wasn't either there wasn't hurricane damage or there wasn't damage to the windows and doors. Isn't that right?
What the insurance company has done is simply opined that they do not believe there's any damage. Obviously, the plaintiff in that case opined that they do believe there's damage. That's why it's submitted. This is a dispute under the insurance policy.
Is the judicial economy question at a wash in a way? I mean, judicial inefficiency could be suffered depending on the outcome either way. If you go to appraisal, you spun your wheels appraising the amount of a loss/claim, to be agnostic on that right now, that may, at summary judgment, as Judge said, be determined as not coverable. And if you go the other direction, you could possibly be spinning your wheels in the circuit court and not have the parties didn't avail themselves of the supposedly more efficient way to assess the amount through appraisal. So it's kind of a wash here, as far as judicial economy.
What's been noted to be, I guess, more economical, I think that was some of their articulated reasoning within Romay, but I think the idea, as far as economy is concerned, is that the number of experts, the amount of time taken in the actual court at trial is lessened because it is a binding determination as to amount. So the coverage defenses, which is another aspect of that coverage, you have, does this contract apply to the issues at hand, whether or not they will ultimately be borne out, or is there a defense to coverage? We have, at least through the appraisal process, a binding amount of loss where that can be taken to trial, the coverage defenses can be applied, and they can say, look, for instance, this was inflated by the plaintiff, or this was, a misrepresentation or something of that nature. The binding amount of loss was, say, $1 million. We're not awarding that, but it foregoes. And again, of course, there are scenarios where a trial could be more economical than an appraisal. I think the sentiment is that generally an appraisal is likely having.
That's not, I mean, how is a court supposed to weigh that in terms of applying the policy language? Well, is this going to be more effective? They can't. You got to work with the language of the policy, whatever it says or doesn't say about the appraisal process. Candidly, having sat on a few of these appraisal cases now, it seems to me that the entire process is, at least in terms of what's formally spelled out, there's not a lot of details that's brought in other than this is what the appraisers ought to look like, and this is, if we dispute the amount, this is what we do with it. Other than that, you all are kind of asking courts to fill in gaps about how this process is supposed to work, right?
That is frustratingly correct, Your Honor. That is precisely so. The clarity in the policy, I think no one wishes for more clarity than I do, because ultimately the argument here and the belief here is that it's been noted, much like arbitration, it's been likened to arbitration. There's a belief that
it's not, and that's the thing though. I know people keep liking it, but it's not arbitration because you're not taking it out of the litigative process and putting it into an alternative dispute resolution process, in toto. Rather, you're plucking out one issue and trying to figure out when does it make sense for us to just informally get together. You pick a side, you pick an appraiser, they pick an umpire, and then they come up with a number. And making that determination of when it's most efficient to do so, I don't know if the courts are the best ones to make that call.
Basically, it's hard to argue against that in the sense that,
so that's more of a vent, I guess.
The process is intended to be more efficient than perhaps wasting, more time in actual court, so to speak. But at the end of the day, certainly it's not a perfect process. And I think, as Your Honor has noted, it is not an exceedingly clear process. The sentiment is simply, if we involve two essentially experts on each side and we have this sort of arbitrator to determine what that amount is, we can plug that into a later determination. And I think through all of this, it's been absolutely clear that the ultimate determination of liability and coverage Again, I hate to split those two definitions of coverage into whether or not ultimate liability will attach coverage, as in whether the defenses will succeed or fail, and just does this contract apply to the substance of the case at issue, which I think is the sort of coverage we're looking at applying to the loss. But in this instance, we believe that the trial court found that the matter was ripe. I mean, again, regardless of whether this is divided into a claim or a supplement.
Why shouldn't we follow?
I think here it's actually possible to follow Ironwood, to adopt this definition of claim and supplemental claim for the purposes of determining whether or not it was ripe. To see that here, this letter issued on April 13th from the insurer saying, we don't think there's a loss. And I think that's very important language. We don't think there's a loss. That's simply a dispute as to whether we do.
And how is that different?
So in Ironwood, the claim there is that post-loss obligations had not been complied with to the degree that they were not able to make it.
More to Leeward Bay.
This is essentially Leeward Bay. It is not a fraud case, but I guess the request here is that this court follow Corridori Michigan Condo, where it says any coverage denial must preclude appraisal. But that's not really what Ironwood said. Ironwood said it is not ripe until a coverage determination is made. The objective test we're going to use for whether a reasonable investigation has been had, whether reasonable compliance with post-loss obligations has been had, is whether or not the insurer has actually been able to make that coverage determination. Here, that April 13th letter said, no, we're not going to cover, and it doesn't say because this policy doesn't apply to your roofs. It doesn't apply to your roofs.
Matter the reason, if, as long as they've made a definitive statement saying, cross the Rubicon, as long as they're saying, we're not, there's no coverage here, we're not going to pay you.
Well,
isn't that it? I mean, that's.
I don't think so, because again, there are two types of coverage. This is a contract claim. Does this contract apply to my house? Does this contract apply to the fact that a hurricane hit it? That's why the scope is a loss. There's coverage for the loss. They paid for a hurricane damage to this property on this very same day where this is
submitted the roofs and doors, the windows and doors claim a year and a half after the hurricane. And so, like my colleagues have pointed out, the insurer denies coverage on that at their peril for what could occur if a trial judge decides that there is coverage. But their one view of this is that you're jumping the gun and trying to use the appraisal award to cram down a settlement that would encompass the payment for the windows and doors, because by the time your appraisers issue that award, the insurer's not going to have the appetite to defend the coverage piece. And you're going to be yelling bad faith every step of the way. So isn't that where this shakes out as a practical matter?
Well, Your Honor, I think it's a practical matter. I have not yet met an insurance company whose appetite for defense has yet been filled. But I think, at this point, sure, there could be a scenario in which this is slightly more advantageous, but honestly, I don't think the appraisal process is more advantageous to one side or another. I think it is more advantageous to both. This is something where both sides are equally represented, where both sides just manage to do this much more quickly on average and much more efficiently. At least that's how the wisdom goes. And that ultimately the defenses, where coverage here has been admitted. I hate to keep using this word, but the policy applies to loss. Your Honor, I would posit they're not separate. There is one policy.
That shunts us back into the supplemental versus initial. Okay, so you're saying, let me see if I can catch up here with your rationale. You're saying that, okay, coverage has been admitted. So if that's, okay, so coverage has been admitted, therefore we get to go to appraisal. But there's two reasons that the insurance company, and I'm going to botch their argument and he gets time to correct me. There's two reasons the insurance company is going to say no. One is because it's supplemental, which is, hey, it's supplemental, it stands on its own, and we denied that in toto. And two, I forgot the other reason, but never mind. But anyway, go on. But
well, I think
why is it so? It's supplemental because they are already adjusted. They've already adjusted. Is it supplemental because they've already adjusted the initial claim when the supplemental claim was made, or because as the time when we really decided to go to appraisal, the initial has been adjusted?
So that's actually a very interesting question. You find the timeline kind of floats a little bit as to when this supplemental claim ultimately arises between these various cases, because there is no clear definition of when adjustment finally concludes? Is it when they make a coverage determination? Is it when they
cut you the check?
Cut you the check? Is it when they come up with their own estimate? I think ultimately,
what if they reverse their original coverage determination
as they have here? I think that's why the appropriate scope is the loss. And to Judge Librett's question, I think the issue here, this complete denial, that was the issue in Leeward. That wasn't just an allegation of fraud and a timing issue. That was, we have completely and utterly denied this. That is why this court has issued a certification of conflict with the opinions from the 4th DCA and Corridori and so on and so forth. Because those opinions stated when there is any denial of coverage, a hold or a complete, forgive me, I forget the precise wording, but a complete denial of coverage, it cannot be appraised. This court said, no. A complete denial is an absence of coverage. It is a complete void.
But then here we have this hybrid, chimera, or what's the chupacabra, which is, there is a complete denial where what coverage was admitted, where there is no question of amount as to that portion of the coverage that was admitted. So we have, this is tantamount to a complete denial. You said, if for the loss, it's not a complete denial. And I'm not sure if that's not too clever by half. Maybe it's something different than that, but we have a complete denial of the only thing left in controversy.
So again, we have a complete denial of payment. What we actually have is a determination of zero. We owe you zero. There must be an imputed amount, because basically through clever language, I can simply say, instead of saying I owe you $0, you think I owe you $100, there's a dispute. I simply say I refuse to make a determination because I don't believe I have to. But what you've done in fact is say that, or what I've done in fact, is simply say, I believe that the scope of loss requires no reimbursement, ergo my dollar amount I put forth to you is $0, because that's the check I'm writing to you, zero. So
let's go ahead and wrap up. You're going into a little over 20 minutes.
Yes,
we've given you a lot of questions.
And I guess with that, if there are no further questions, we rest on our briefs. We believe that the trial court has ultimately determined that this matter is ripe for appraisal and found that there was coverage for the loss as appropriate and as articulated, as the trial court articulated, relied on Johnson, Lycia, Leeward, and Bellagio. And accordingly, we request that this court affirm the trial court's order. Thank you.
Thank you, Your Honors. The bottom line in this case, and what's really dispositive here, is that we have no dispute regarding the amount of loss. And all the case law from all the DCAs, from the Florida Supreme Court.
And the reason we have no dispute as the amount of loss is that the insurer fully satisfied the claim and said we're not going to do one then die on the windows and doors claim.
Correct.
Period in the sentence. So what's left to appraise?
Correct. There's nothing left to appraise, and that full denial of the supplemental windows and doors claim was a coverage determination. That's a coverage decision.
And that hasn't been litigated by the trial court yet. And under the present order, the trial court will either do that while you're fooling around with your 3 appraisers, or it will do it after you get back with the appraisal award. In which case, if coverage is granted, you have a number. If coverage is denied, it'll be, you've got another problem, an extra contractual thing.
Correct, Your Honor, pursuant to the order on appeal. But the problem with that order is that it's sending something to appraisal that's a judicial determination regarding coverage. And that sort of
Is that your position that they're asking for the appraisers to determine coverage?
Yes, it's the equivalent of that, because it was a full denial of coverage for the windows and doors claim. So for that to go to appraisal, the appraisal panel has to look at determining, well,
it has to assume coverage, doesn't it? I mean, under the language of the appraisal provision, they're not determining coverage, they're determining the amount of loss. That's the point of the appraisal. So it's essentially hypothetical unless and until the trial court declares that coverage is, that the policy provides coverage for the windows and doors.
Well, the appraisal goes beyond that, because the case law says that once you put a claim into appraisal, the appraisal panel can determine causation. But the problem is here that we denied all coverage. We said this is not.
Only in some circumstances would that bear upon the coverage determination by the insurer incidentally, right?
That's correct. In some circumstances, the insurer is not basing the coverage determination on causation. But here, if you look at the denial letter on the supplemental windows and doors claim, it's saying there's no Hurricane Irma damage here to these windows and doors. And the appraisal panel will have to address that particular issue, which is a judicial.
Whatever they say about it is binding on no one. This is not akin to deferring a matter over to an arbitrator to determine the scope of arbitrability, where you could potentially have the ADR decider deciding whether or not this is a dispute that they can decide whether or not it's appropriate within their warrant of power. Rather, this is just appraisers that are, whether there's coverage or not, in theory, they would just be giving you a number. And how they come about with that number is how they come about with it, but the separate issue would remain unresolved and reserved for the trial court to decide whether or not there's coverage.
Your Honor, the Johnson case is actually instructive on this point, and it indicates why this is strictly a judicial issue that cannot be sent to the appraisal panel. It says causation is a coverage question for the court when an insurer wholly denies that there's covered loss. And even more so beyond that, Your Honor, to really
not a lot of wiggle room in that pronouncement.
Exactly, Judge.
So you're saying, but that doesn't get you across the finish line, does it? You say, well, if we do send it to the appraiser, he or she they shouldn't determine causation.
It would,
okay, but that doesn't mean that doesn't totally undermine the appellee's argument that it's right.
Well, it would, Your Honor, because it's impossible to put a number on the amount of damages without also determining they came from Hurricane Irma. Because the whole purpose of appraisal
does it get around? Okay, so but for practical purposes, the appraisal panel has to presume causation to get to the point where they can say this is the amount of loss. I mean, I've seen these other cases where I talk, well, should they parse it out? Should they say, well, if this is, you could still conceivably go to appraisal and then have that appraisal award be litigated to death for good reason, because well, this portion of the appraisal award was presuming a causation question that we would like to contest here in circuit court. Even if the amount for what they said was caused by Irma was what they said it was, as we agreed to by the appraisal award, we can still contest in circuit court thereafter the causation itself. Isn't that a way that it could be handled?
not consistent with the case law, Your Honor, just because there's no dispute on dollars and cents between the parties. The initial roof claim has been fully paid. The supplemental windows and doors claim, we say no coverage. We're not saying it's 1 million versus 3 million.
Let me ask you this real quick though.
Yes.
Because your time's running out. You don't need to go that far to make your argument though, right? You don't need to say that it's inevitably going to include causation. Your argument that we should reverse the ordering appraisal could be based on something less than that, isn't that right?
Correct, Judge. It goes more towards the economy issue that's come up. And the Johnson case actually adopts the analysis of Judge Cope in the Gonzalez case out of the 3rd DCA. And what happened in that Gonzalez case is that State Farm wholly denied coverage. The trial court sent it to appraisal anyway. And State Farm was able to convince the umpire, State Farm's appraiser and the umpire agreed, no coverage here, this is $0. And that's how the award came back, saying no coverage. 3rd DCA reversed that and said, no, that's judicial determination. The appraisal panel cannot determine that there's no coverage here and issue a $0 award. Florida Supreme Court adopted that analysis. So if we send this particular case to appraisal, it's going to be an argument, while there's no coverage here, it's $0. And if it comes back like that, it will have been a futile gesture. It will be reversed. And it's just going to cause more problems for the trial court, because then instead of litigating and doing discovery on breach of contract, now we're trying to confirm an appraisal award and we're fighting over what amounts to a nullity. So from an economy standpoint, it supports reversing the trial court's order and litigating breach of contract.
Thank you, Mr. Miller.
Thank you, Your Honor.
Okay, this will be a good point in time for us to take a break before we go into our next stage of the docket.